Good afternoon and welcome to our first Lunch and Learn webinar in 2021. First, we have to apologize for having some technical difficulties of our own in getting this program up, but we are up and we're very happy to proceed, and we're thankful for all of you to join us. Once again, I want to remind you that the views presented in this program are our own, and they do not represent the views of any other law firm, the court system, the administration of courts, or any other entity. And we also want to remind you that we will take questions at the end of the program, of the presentations, and all questions are confidential. So please do not be afraid to ask us a question. And finally, this program is designed for the public. It is not a program that was designed to be for attorneys or legal professionals. It is designed to provide information, general information to the public. And one last note, on this particular series, there are lots of individual topics within the topics, and we can get further involved in each topic, and we may well do so on a webinar. And for those of you who were not able to attend today or have a friend who you think this information would be helpful, please be advised that we will have it available, recorded on our website. You just have to, in about 2 weeks, you just have to go to our website, pffamilylaw.com, click on webinar, and then go to YouTube, and you will find it there. And so without further ado, the program is broken into 5 parts. The first part will be presented by my colleague, Mr. Shane Duffy, Associate Attorney here at our office. He will be discussing the actual petition, the commencement of filing a divorce action. The second part of the presentation will be presented by Meryl Hafe, partner of this law firm. She will be discussing the actual financial affidavit and discovery referring to the documentation that you must turn over to the court and your adversary in any child support proceeding. The third part of the program will be Ms. Maxine Donskoy, partner. She will be talking about the Child Support Standards Act, the governing law that guides us as to a child support order or agreement in this state. She will also be discussing the add-ons. So if basic child support consists of food, clothing, and shelter, there are a series of add-ons. Some are what are called statutory or mandatory. They must be included in a support order, and others are discretionary, and she'll get into that. And then finally, I will come back and I will be talking to you about the support collection unit, cost of living increases, modifications of a child support order, and income above the cap of $154,000 combined income as it is presently. And then finally, we'll hopefully have some time for some questions. We will end at 2 o'clock. We thank you for your time and your patience. So without further ado, I introduce my colleague, Mr. Shane Duffy.
Apologies for slight technical difficulties again today.
Here we go.
We'll have to work this way.
Apologies, everyone's having some issues with the PowerPoint screen sharing, but I'll begin now, and then we'll see if we could figure it out along the way. So my name is Shane Duffy. I'm an associate attorney here at Fersch LLC, and I'm going to be discussing with everybody what goes into a child support petition in the family court. And I'll be going through item by item here on the petition, what should be included, and what each section kind of entails. So if you can see here, we'll start at the top. It's just the case caption. So for the purposes of this, we're just going to assume you're the one who's bringing the petition. So you'd be petitioner. The party that you're seeking support from would be the respondent. So so we'll start with number 1A is just you would put your own address there. And the footnote there just denotes if your address is confidential, you do not have to include it here. You could simply state that your address is confidential. But in order to preserve the confidentiality of your address, you're going to want to file an address of confidentiality affidavit with the county clerk in the county in which you are bringing the child support proceeding. 1B, again, is just the respondent's address. Most of the information here on the first page is going to just be basic biographical, but it's important to make sure everything's accurate if you're seeking a court order based on this information. So moving on to number 2, right now for the purposes of this webinar, we're just focused on child support. So you would check the second box there that you have a child in common. And then in number 3, you would just name the child and include their birth date. So we're going to move on to page 2 of the petition now, starting with number 4 here. And number 4 is just what has established the paternity if it has been established. So in order to seek the support, we'll assume for the purposes of this that the respondent is the father. That is certainly not always the case, but there needs to be some basis for the court to grant a support order if the father is the other parent is the father of the children. So the options here are, well, the first thing you want to list the name. And then the options are that you were married at the time the children was conceived or born. An order of filiation was issued. What an order of filiation is just a court order establishing the paternity of a child. And then the next option is that there was an acknowledgement of paternity that was signed. So if you have an acknowledgement of paternity and order of filiation, you want to attach it to your petition as it denotes there. The next is number 5. And here, again, you should include the name and the address of the mother, assuming that you are the mother. And again, here, if the address is confidential, you want to denote that. Number 6 is related to the employment of the respondent. If you know who their employer is and where their employer is located, you would check the box there that says employer, and you would include the name and the address. Number 7 is regarding support collection unit. I'm not going to go into too much detail about the support collection unit because, as Ms. Fersch noted, she's going to be speaking about that during her portion of the presentation. But the default language here has the petitioner seeking their services. And based on what Ms. Fersch has to say, I believe that most people will agree. You want to use a support collection unit. But if you don't, these 4 boxes here are some of the reasons why you may not want to. You simply don't wish to apply for their services. You're not eligible for their services. But again, Ms. Fersch will go into more detail about the support collection unit during her portion. Number 8 is regarding that there's no other applications that have been made to any other judge or any other court seeking the same relief. So you can't file a support petition in Kings County and in Queens County. You can't refile once your petition was denied or a judge refused to enter an order on your behalf. You can't simply keep reapplying and reapplying. Once an order has been entered, there's a time period wherein you can modify. And again, we'll be touching on that later in the presentation. This next section here, the wherefore section, is very, 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 very critical. So you want to pay super close attention to how you fill out this section. This is the relief you're seeking from the court. So here you can, this is the default language. If you go to the court's website, nearcourts.gov in the family court section, they have all the forms here. So you could either fill out a PDF form like this, where you just simply check the boxes, or you could do it by, Word. I believe they have a Word perfect version up there. But you could also include that you're seeking legal fees, that you're seeking statutory and discretionary add-ons, which Ms. Donskoy will go into during her portion of the presentation. And more importantly, if you're seeking an order above the statutory income above the statutory cap of $154,000, you also want to include that here, so that's clear for the court. So these three paragraphs here are all related to items that will be discussed by other people, but also touch on them quickly. Number one, which actually started in the prior slide, is regarding the cost of living adjustments. Ms. Fersch will be speaking to you about that. Number two is just that a child support order can be reviewed and adjusted, which again will be going into modification later in the presentation. Three is just that both parties must keep the support collection unit, if you elect to use their services, informed of their current addresses. So this petition needs to be signed and notarized and then filed with the court. So right now, the only real way to file a support petition with the court is through the electronic document delivery system, and that is on nearcourts.gov. So it's important to file as soon as you can, because you want to preserve the retroactivity of your petition. Right now, you would just be kind of saving your place in line until these petitions are heard in the family court again. Right now, things are, the future is unclear as to in what capacity they're going to reopen, and if it's going to be in person. I'm sure it'll continue to be virtual, but it's all speculation. So right now you want to file, and then when the courts do hear your petition, you can seek the child support arrears back to the date of which you filed. Simply being separated from the other parent or the other spouse will not be enough. You want to file as soon as you can to preserve your ability to seek those arrears. So at this time, I'm going to pass over the presentation to Ms. Merrill Haight. She's a partner here at Fersch LLC, and she's going to be discussing with you financial disclosure and child support proceedings. Thank you.
Good afternoon. Thank you for joining us. And yes, today I will be discussing financial disclosure. So after you filed your petition in the family court, you should start getting prepared with the financial documents that you will need to present to the court and to turn over to the other side. Okay, so the guidance as to what documents need to be disclosed can be found in the Family Court Act, Section 424A. And these are the required financial disclosures. First here, financial disclosure affidavit. So this is the starting point, and I'm going to go into detail about how to complete a financial affidavit on the next slide. You also will want to attach recent pay stubs and your most recently filed state and federal tax returns, including W-2s. Attach those to your financial disclosure affidavit. Okay, here is the first page of the financial disclosure affidavit, or FDA as we sometimes call them. In the bold print here is the list of the documents that you'll need to attach: tax returns, W-2s, tax statements, as well as a request that you attach information related to your health insurance. So if you have coverage through your employer or a private plan, you'll want to include that as well. Number one here, income from all sources. This is where you list your income as wages or your salary, where you work, how many hours per week you work, how you're paid, weekly, biweekly, monthly, deductions from your pay. So you see the categories here: Social Security, Medicare, federal income tax, New York state tax, New York City tax, and then any other payroll deductions. You would complete that section here. And then any other members in your household. And if you have dependents, if the other members of your household contribute income to that household, you must list that here. Self-employment income. So if you have your own business, you have to disclose that income here, as well as in C, interest or dividend income that you receive. And then finally at the bottom, there are other sources of income, of course. If you have any of these, you'll want to be fully transparent and disclose these to the court. Okay, moving on to this next page. If you have any other income, perhaps, a personal injury settlement is listed here, or periodic income, or money, goods, and services provided by a friend or relative, you'll have to disclose that. Okay, number 2, assets. Here is where you list all of your assets in your name: savings account balance, checking account balances, if you own a car, if you own a residence or any other real estate, you'll want to list that, including the approximate value. If you have other assets or any licenses, they ask you to list those here. And then number 3, deductions from income. So it says the court allows certain deductions from income prior to applying the child support percentages, which you'll hear about in just a minute. So you'll list the deductions that apply to you here: unreimbursed employee business expenses, if you're paying maintenance to another party who's not part of this action, or child support you're paying on behalf of other children not subject to this action. You complete that section here. And then health insurance is the next section at the bottom here, going on to the next page. Okay, so this is where you complete the type of health insurance that you have, who's covered by it, and what kind of services are included. The letter B here, you list any childcare that you have on behalf of the child or children, the cost of that childcare, as well as in letter C, if there are educational needs or expenses, for example, a private school or tutoring, that would be included here. And it also asks if you have life insurance, so you'll want to make sure you include that if you have any life or accident insurance. Okay, number 5 at the top, variance from the percentages. So in this section, you can list any factors that may be relevant to the court as to why you think the court should deviate or go above the $154,000 current statutory income cap. And you'll hear about that more in just a minute. So if there are factors, you would want to list them in this section. Number 6, expenses. So here is where you list your expenses. We usually do it on a monthly basis. You can do it on a weekly basis, but just be very clear and be as accurate as possible when you're doing this section, and make sure that you include all expenses that you incur on behalf of the subject child. And that continues onto this page. And then finally at the bottom, liabilities, loans, and debts. So here you would list any debts that you have or outstanding obligations, like student loans or credit card debts, a mortgage, that would all be listed here, car loan, something like that. And then finally, you would sign this document before a notary. So this is a sworn statement. You are swearing to the court as to the accuracy of this document. And if you have an attorney, they will sign it as well. So after you exchange financial disclosure affidavits, there is an opportunity for additional discovery or additional document exchange. Some of the most common documents that are exchanged in these child support actions would be checking or savings account statements, prior tax returns. So usually you can seek up to 3 years of tax returns. If you have a very young child, you really are only entitled to tax returns from the time the child was born. And that's true of these other documents as well. So usually it's 3 years. Sometimes a court will permit additional discovery beyond 3 years or from the date of birth of the child if less than 3 years. Credit card statements. So this can be helpful when someone owns a cash business, for example, and you want to see what that party is spending in order to impute income to them or show the court that they in fact have more income than is shown on their tax return. Business records. If the other party owns a business or if you own a business, you may be required to disclose the details of the income of that business. And so once discovery is complete, if the combined income of the parties is less than $154,000 a year, the court can then enter an award of child support. If the combined income is over $154,000 a year and the parties cannot agree, then the court would hold a hearing to determine how much income to apply to the Child Support Standards Act, and whether they're going to consider that income. And so without further ado, I'd like to introduce Maxine Donskoy in my office, who will be discussing the Child Support Standards Act and add-on expenses.
Thank you, Meryl, and good afternoon, everyone. Okay. I will be discussing the Child Support Standards Act, as Meryl just mentioned. The Child Support Standards Act is the statute, which is also known as the CSSA, and child support in New York is governed by this statute. It's found in two statutes, actually, in Domestic Relations Law, Section 240, and Family Court Act, Section 413. The DRL, which is Domestic Relations Law, is used for actions in the Supreme Court, and the Family Court Act, which is known as the FCA, applies to matters in the family court. And since we will be dealing with family court actions, the FCA is what applies here. Every child support order or agreement must comply with the CSSA. This requirement is mandatory and it cannot be waived by the parties or their attorneys. If parties wish to deviate, which they are more than welcome to do so, from the CSSA guideline amount, which I'll be discussing in detail in a little bit, they can do so by agreement. However, the agreement must state what the guideline amount is, and that thus the CSSA calculations must be listed in the agreement and stated along with the reason why the CSSA amount is not being used and why the parties are deviating. The court can also, in their order, deviate from the CSSA, but they must state a reason as to why they are doing so in their order, and they must state that the deviation is just and proper. In calculating child support, the guideline amount automatically applies to the combined income of both parents up to a set cap on combined income. For income over that amount, the court has the discretion to use certain factors that Ms. Fersch will discuss in detail in determining child support over the cap. As of March 1st, 2020, the statutory income cap is $154,000. The income cap for child support calculations is increased every 2 years in even years in relation to the Consumer Price Index. There are percentages in determining child support pursuant to the Child Support Standards Act, and it depends on the amount of children in your household. So if there's one child, it's 17%, 2 children, 25%, 3, 29%, 4 children, 31%, and if you have 5 children or more, no less than 35%. I will be sharing right now, actually, Child Support Standards Chart, the first page of the Child Support Standards Chart, which was prepared by the New York State Office of Temporary and Disability Assistance Division of Child Support. And this chart, which is voluminous and it could be found online, or if you'd like, I can send it to you, just shoot me an email. And it gives income ranges and child support guideline amounts pursuant to those income ranges up to the cap. It also lists what the cap is, which currently $154,000. It states what the poverty income guidelines are and what the self-support reserve is. So there are two elements of child support pursuant to the CSSA. There's basic child support, which is used for food, clothing, shelter, and add-ons, which are statutory. Basic child support is a set dollar amount of support, which is set in accordance with the CSSA guidelines. And it's calculated in two parts. Child support based on the first $154,000 of combined parental income, which is known as the statutory cap, meaning depending on what the cap is at the time that you are seeking child support, it would be child support based on that first combined income cap. And then if there is income above the cap, there would be a second calculation based on the combined parental income over that cap. And that determination would be either by agreement by the parties or entered in the court's discretion. And so in addition to that basic child support, the CSSA requires that certain statutory add-on expenses be included in all child support orders, and those are unreimbursed medical expenses and child care expenses. There are other discretionary add-ons that may be included, which I will get to in a little bit. However, these two expenses and add-on expenses are what are mandatory. So you may be wondering, how do I calculate child support pursuant to the Child Support Standards Act? Well, the CSSA requires three steps to be followed. One, you have to determine what combined parental income is, and I'll be sharing a slide next which will show what the CSSA defines as income. And so both parents' adjusted incomes must be calculated and combined to obtain what is considered the combined parental income. And then adjusted gross income consists of mandatory income plus additional income, if any, and less any statutory or allowed deductions. However, you must be aware, and you should note that courts are not bound to use the income reported by either party and are authorized to impute income to either parent if they see that something is off or not in accordance with what the discovery shows. So after you determine what the combined parental income is, you would apply the statutory percentage based on how many children are subject to that order. And then you would prorate each parent's share. So from the combined basic child support, each parent's share is prorated in the same proportion as each parent's income is to that combined parental income. And so here in this slide, you will see what is income pursuant to the CSSA. There's mandatory income, and the mandatory income is gross income as it should have been or should be reported on your most recent income tax return, certain investment income, and additional income from workers' compensation, disability benefits, unemployment benefits, pension and retirement benefits, fellowships and stipends, and annuity payments, retirement benefits, any spousal maintenance received, whether it's temporary or post-judgment. So if you're receiving spousal maintenance from a prior relationship, or even if you're receiving spousal maintenance due to this relationship that you're in, that would be considered as income to the receiver. There is something called additional income as well, which could be meals, lodging, memberships, automobiles, or other benefits that are provided as part of compensation for employment to the extent that such benefits constitute expenditures for personal use. Then there's money, goods, or services provided by relatives and friends. So if you have relatives who are maybe paying your rent for you or buying your groceries regularly, then that could be income that would be certainly imputed to you if it's regular and ongoing. If the court finds that somebody is not working to avoid child support or working less so that their income is less, income can be imputed to that parent based on their former income or resources available to him or her. So after you have that income that's calculated, there's certain deductions that can be deducted from your mandatory or additional income to reduce the amount of your income pursuant to the CSSA. And those income deductions are certain unreimbursed business expenses, child support actually paid to another party. So if you have a child support order that you are paying to another family, to another previous relationship, to another child, but there must be an order or an agreement, and you must actually be paying, you can't be in arrears. Any maintenance paid, so if you are a maintenance payor, that could be deducted from your income, public assistance, SSI, and if you're in New York City local taxes, Yonkers taxes, actually paid, and FICA taxes are deducted from your income. So here you'll see an example for an example of calculations of child support for 2 children. Under the CSSA, the percentage for two children is 25%. And here we're just using some easy numbers. The adjusted gross income for the custodial parent is $35,000. The adjusted gross income for the non-custodial parent is $115,000, making the combined parental income $150,000, with the custodial parent's pro rata share being 23%, and the non-custodial parent, who is the payor, being 77%, that pro rata share. Percentage of 25% results in the combined child support from both parents being $37,500. And so then you take the pro rata share of that combined child support amount. And so 77% attributable to the non-custodial parent is $28,875 per year, or $2,406.25 per month in basic child support. And since the combined income in this example is under the statutory cap of $154,000, no further calculations are necessary to be done. And in addition to this basic child support, the party shall each pay his or her pro rata share of add-on expenses. So the non-custodial parent would have to pay 77%, and the custodial parent would have to pay 23%, unless the parties enter into an agreement as to otherwise. And so now the add-on expenses. The statutory add-on expenses are unreimbursed medical expenses, which can include health insurance premiums. If there is health insurance available, parents they're required to provide that health insurance for the child or the children. And the cost of health insurance and unreimbursed medical expenses shall be allocated in the same proportion as each parent's income is to the combined parental income, meaning that each parent shall pay his or her pro rata share of those expenses. In addition, a statutory add-on expense is childcare expenses. However, the difference between childcare and unreimbursed medical expenses is that childcare expenses are not automatically awarded. The CSSA provides conditions that must be met before those childcare expenses are ordered. And the conditions are when a custodial parent is working, seeking work, or is in school or training that will lead to employment. And so only then can the custodial parent receive child care expenses that pro rata share from the non-custodial parent. The child care expenses must be reasonable, meaning they must be reasonable as to where you live and the amount of time in the vicinity of where you are. So New York City child care expenses are way more higher expensive than they would be in other parts of the state. And so then those expenses would be allocated in the same proportion as each parent's income is to the combined parental income, meaning each parent will pay his or her pro rata share. Then the other discretionary add-on expenses are educational expenses, tutoring expenses, extracurricular activity costs, and summer camp, which could sometimes be considered childcare expenses if that summer camp is in lieu of maybe a nanny or a daycare and done during the time when the custodial parent is working. The discretionary add-on expenses are awarded based on what is in the best interest of the child, maybe what has been in the past, the sort of status quo of the family, and really how much money and resources are available to the parties to the case. So there is nothing set in stone. It's really a case-by-case sort of thing. And that's pretty much it for my portion of the presentation. As I've discussed the CSSA and child support awards and agreements up to the statutory cap of $154,000. Ms. Fersch will be discussing what factors the courts can consider when they use their discretion to award child support over that statutory cap. And just one more thing, that if anybody does have any questions, I ask that you ask those questions in the Q&A box and not the chat box, because if you ask in the Q&A, then those questions will remain anonymous. So thank you so much. And without further ado, here is Ms. Fersch.
Hello again. Let me start. And I'm going to get some assistance here from my colleague. Oh, I see.
Today we're having some technical difficulties.
Okay, then I can do. Okay, got it. All right. So the first topic is what essentially Ms. Donskoy left off with, which is when can the court deviate from the statutory formula and either order less support. That's always a possibility because it would be unjust and inappropriate. Then the formula applied to the income up to the cap would grant. Or when can the court apply the formula, again, what Ms. Donskoy went over, the 17% one child, 25% two, 29% three, 31% four children, to income above the cap. So the factors are, I hope, let's see here, there we go. These are the factors, and there are essentially no other factors. And so it's important that you look at these and think about whether or not any of these factors apply to your particular situation. I'm just going to touch on a few of them. One in particular, number two, the physical and emotional health of the child and his or her special needs. This is an important factor because if there is combined income above the cap and you have a child with special needs and those special needs are not covered by some form of government program, for instance, when the child's very young, it could be early intervention, but beyond early intervention, if the child requires specific therapies, occupational therapy, physical therapy, or whatever, and there is an out-of-pocket cost, that would be a basis for the court to apply the formula to income above the standard, the presently $154,000, the cap. Number three is an important factor, and people often try to use this factor, and it references the standard of living the child would have enjoyed had the marriage or household not been dissolved. Now, if you're married and you have lived together for some amount of time and created a marital household with a standard of living, this factor does apply. Where it becomes highly problematic is when the parties are not married and their relationship, perhaps they live together for a very short period of time or never at all. In that case, you cannot create a standard of living as if you live together. So you would not be able to use this factor to apply to the income above $154,000. Another factor, I'm going to skip to number 7, a determination that the gross income of one parent is substantially less than the other parent's gross income. So this factor applies when one parent earns, let's say, $67,000 and the other parent earns $967,000. There's a huge disparity between these two households, and obviously then the standard of living in each household, the available funds for the lesser income parent to provide for the support of the child comparable to what the other child, the other parent can provide. So this is an important factor and does apply in many cases. And then finally, I'm just going to cut to number 10. Any other factor the court determines is relevant in each case. This is often referred to as a catch-all factor, but it's problematic because there's very little times or case law where a court has used this factor to create, if you will, a 10th basis for applying the formula to the income above 150,000. Now, you might ask, if in the example I gave, one parent earns 950,000, the other parent earns 67,000, so the combined income in that case would be, I think, 1,017,000. Is the court then, if there's one child, going to apply 17% to that income, combined income above the 154,000? So in other words, 1,017,000 less 154,000? The answer is no, they will not. So when the court looks to apply these factors to whether or not it will use the Child Support Standard Act percentages to the income above 154,000, they can cut it off at any point. They could say, well, we're going to use combined income up to 350,000. That's actually the number that Brooklyn Supreme Court often uses. Manhattan Supreme Court will use, they have used up to 800,000, but that was really a special in a particular case. Most often $500,000 or $600,000, but that's not in every case. And so in the family court, the court is less likely to set a cap and more likely to look to the needs of the child, which creates some problems for parents, especially in disparity of income cases, and especially in cases where there is a child who has special needs and that income above the cap really does need to be raised in order to accommodate the needs of the child. I'm going to move on now to the support collection unit. This is actually an income deduction order. So you have a right when you go into court as the petitioner and you're seeking child support to have an income deduction order. It is your right and it cannot be taken away except for good cause. And I list here, you know, what essentially would good cause mean? That means that by having this income deduction order, it's harmful to the debtor and their ability to earn the money that you actually need to be paid to you for child support. I want to mention here that this topic, and up on the screen, we provided this information before, but up on the screen, and you'll be able to get it from us. You do not need to write it down now, are the support collection units throughout the city. But this support collection unit, if you are trying to negotiate a child support agreement, it's a factor that, you know, it is your right. If you're the petitioner, you can give it up, but you have some leverage there. What are you going to get in exchange? If you believe that the other parent is going to pay the support like clockwork on time every month, or however it's supposed to be paid bi-weekly, then you don't necessarily need the support collection unit, but it still is your right. And they will provide, not only do they provide a record of what actually has been paid, if there are arrears after 4 months, they can seize the other party's driver's license, they can grab income tax refund monies. They have a lot of authority as a separate government entity that you don't have without going back into court. So there is a great benefit to the support collection unit. If you agree to waive it or give it up or not use it, and the other parent begins paying but then stops paying, you have a right to go back to court and say, hey, I want the services of the support collection unit. But at that point in time, you have to go back to court and ask for it. If you currently have an order that says, you know, doesn't waive the rights to the support collection unit, you can certainly contact any one of the support collection units listed on the screen and open up a case. It's a case in your name in order to garnish the wages of the other parent. One other point I'll make, If they are self-employed, it becomes really impossible to garnish their wages. And so you can still open up an account. They have to pay into the support collection unit. Support collection unit will keep a record, will, seize income tax refunds if they're in arrears, etc. But you will not be able to garnish the wages. And one point I neglected to make with regard to the factors, the 10 factors that we briefly discussed that would allow you to apply the formula to some amount of combined income above the cap, that requires a hearing. The court cannot do it. They cannot just say, yeah, you know what? I think you earn 600, you earn 100, that's 700, I'm going to use 450. They cannot do that. They must write a written decision citing 1 through 10, the factors that they used and why they applied the formula to the income above $154,000 according to those factors. Cost of living adjustments. Now, this is also another negotiating sort of thing, but with regard to the family court, if you're using the support collection unit, they will every 2 years apply a cost of living if, according to the United States Department of Labor Bureau, there's been a 10% increase or greater. And then, I didn't put up here, but obviously there's always, if there's a right, there's a way to object to that right. So there is, of course, a basis to say, hey, no, this can't apply to me. But basically, it will happen automatically. Oftentimes, this provision is used when parties are trying to negotiate a settlement, and the respondent wants to pay one amount and they only want to pay that amount. The child's 4 years old and they only want to pay that amount for the next 17 years. They'll say, well, I'll give a cost of living increase. And that's fine, and it can be put in the agreement. But what I have found as a matter of practice is that it gets put in the agreement, but then people forget about it, and nobody does anything, and it requires an accountant to figure out what exactly it is, and depending on how the agreement's written, when is it retroactive to? So it becomes a bit complicated, and if you're going to do that or think about that, you really need it to be, you need to understand it and understand when you would be able to use this so that you actually can get the money that you negotiated to get. Modification of child support orders. For years, there was essentially no way to modify a child support order. It was really incredibly difficult. And then these provisions that are up on the screen right now were put into effect. So let me run through them. These are also provisions, though, that when agreements are reached are negotiated away, or at least the respondent wants to negotiate these away. So let's start with substantial change in circumstances. Factor number 1 cannot be negotiated away. Cannot be. You always have a right to return to court. And again, this is not an automatic modification. This is just you have a right to go to court and say, hey, I need more money to support my child, or I can't afford this order. At the time I was, earning whatever, and now I've lost my job. The company moved to another state. I'm trying to stay here. I'm looking for work every day. Remember that. Keep a job search diary. If you have lost your job, make sure you can show a court that you continue to look for a job at the same income you were earning. But in any event, that cannot be negotiated away. But these factors, number 2 and 3, can be negotiated away. So you have an automatic right after 3 years have passed from the date of the order. So if you enter into an order today, or the court issues an order today, you enter into an agreement today, January 13th, 2021, on January 14th, 2024, you can return to court and seek a modification. But you can't sort of just walk in and say, I need more money. You do have to make some showing that the amount of money you are receiving is insufficient for the support of the child, and why. And then the third factor is there's been a change in either party's gross income, 15% high or low. This obviously can be used by either party to seek a downward modification or seek an upward modification. And finally, I come to, as some of you know, I am a contributor to Forbes magazine online publication. I recently wrote this article about what it costs to raise a child. And so it's here. It's a rather short read, and I hope that you find it interesting. If there are other topics that you would like us to discuss or go into more depth, please just let us know. We're very happy to respond to what people are interested in or need information about. I want to also let you know that the next webinar, Lunch and Learn, the continuing series, is going to be not on a Wednesday. I know that, I believe, and I just want to get to the date. It is on February 16th. It'll be on Tuesday, February 16th, 2021. And in that one, we will be discussing financial disclosure and discovery in a divorce action. So we will be going through the statement of net worth and how to complete it. And I'll just mention now, there are people who believe the statement of net worth should be aspirational and others who think it should be actual. And so we'll discuss both of those on February 16th, 2021. My colleague is now going to help me go to the questions. So the first question is, can a pregnant woman file for child support prior to the baby being born so that the support begins at birth? The answer is yes, you most likely can. But you know, again, there needs to be a live birth. So if the court takes the petition, then the child is subsequently born. More likely, though, those petitions are used to establish paternity so that you can initially establish parent or parentage. So that you can establish parentage does not necessarily, if you're the birth parent, doesn't necessarily mean that the other parent is male. The other parent could be female. But in any event, yes, you can, but it's only going to begin at the birth. The next question is, if the non-custodial parent is the primary breadwinner, but they suffered hardship because of the pandemic and can no longer afford to pay support to the custodial parent, can the amount be adjusted temporarily? The answer there is yes. However, our family courts, with petitions for support that were filed, I'm going to say roughly from February to today, those petitions are not being heard. So there's not a lot of information. In fact, there's no information that we have from the family court on this particular issue. It is, I will say, a travesty. The next one is, does the family inheritance have to be disclosed when it is solely in one parent's name? Well, you have to disclose your assets. So you have to disclose assets that you have. If you haven't received it yet, you don't have to automatically disclose it, but you may be asked to disclose it if the other side knows that you're about to get an inheritance that would dramatically alter your income and standard of living. I actually litigated that issue, and where the father did not disclose that he was about to get $1 million or something, and we won. His child support was modified upwards, and he was found to have been fraudulent, if you will, in that he knew he was going to get it and he deliberately withheld it. How will child support be calculated in New York City if custody is 50-50? So there's a case that's Bast v. Rosoff is the case, and the answer is that the parent who earns less money will be considered the custodial parent for child support purposes, and so that will be the parent that is entitled to support. What if the custodial parent is spending money on frivolous items like designer clothes for the child? Does the non-custodial parent have any recourse? So there is no provision whatsoever that requires a parent who is receiving basic child support to account for that support. Oftentimes, in order to get the statutory contributions that Ms. Donskoy talked about, the child care and the unreimbursed medical, you have to prove bills and proofs that you actually paid it in order to get reimbursement. So there's some accounting there. But with regard to basic support, you do not have to make any accounting. You are not required to. However, if this were to go back into court, and you knew, if this parent wanted to go back into court and seek more money, and then they have to provide some financial information, and it sort of comes out that the money's being spent on, baby Dior clothes, that's probably, or little Chanel purses, that's probably going to be a problem. If the custodial parent is able-bodied, has a skill set and education, it refuses to work for income, does the non-custodial parent have a case to lower their share of child support? I would imagine that if there's a court order, so the court order, if there's an existing court order, that's going to stay in place. So this able-bodied skill set person would have to go back to court, him or herself, to reduce it. So they would have a bit of a problem, because why did they lose their job? Why are they not working? Where's their job search diary, et cetera, et cetera. If this is like you're going into court and this is the person you're going into court against, you would have to, one, try to impute income to them. I think Ms. Hafe touched on that. Again, we have to show, okay, you're doing nothing, you're a sloth, and who's paying your rent? How are you eating? So something's coming from somewhere. So you'd have to prove income in that way. But your question, lower their share of the support, again, it's going to depend on sort of the things that we just talked about. And I think, what if the higher earning parent is forcing the family to live in poor conditions for his convenience? 2-bedroom apartment for family with 3 kids, even though he can afford more, combined income of $320, he makes $220. Will the court award more money for a better living situation? It's an interesting question. So first of all, this is New York. So New York isn't big on, we live in small spaces here. So they're not sort of big on demanding that somebody live in a more expensive or whatever apartment. The issue there would be almost a custodial issue, because if you've got 2 children, teenage children, let's say, who are sharing a bedroom, that might be appropriate. Or you've got a child of the opposite sex sharing a bedroom with the parent after age 5, that can be a problem. So it's somewhat more a custodial issue than necessarily a child support issue. Best methods to prove income for a self-employed person not being truthful about their income on their financial. Well, that one's, of course, one we see like all the time. So some things like a taxi driver was a common one. There sort of are pretty much standard records in the Bureau of Labor as to what their actual incomes are, and you can kind of get the court to to use those figures. But the best method is a standard of living. And don't forget to look at people's online presentations, because we had some charming Father of the Year present that he, whatever, earned $12,000 a year, but he was all over the internet. And this was years ago, with gold chains, Rolls Royces, and so on. So we were sort of able to use that to show that he had quite a different standard of living than he was presenting to us. And I'm going to take the last question: how to add private school tuition into the court order. That is a discretionary expense. In the end, it comes down to a best interest analysis. So can a parent, is it in the child's best interest to attend private school? And is there money sufficient to afford that the child can attend the school, again, requiring a hearing? Thank you so much. It's fun to answer your questions for me. I would like to do it all day, but it is an hour-long presentation. We hope that it's been helpful. That's really our key. Again, if there's more or different information or expanded information on any of the topics we covered today, please let us know. It will be available in about 2 weeks on our website. And again, thank you so much. And hopefully we will see you on February 16th, 2021 at 1 o'clock for number 2 in 2021 of Lunch and Learn. Thank you all so much.